Judgment is expected in the bail application of a 19-year-old Johannesburg learner. Let's go there live.
The medical is set down today for judgment on a bail application, and the court may proceed.
Thank you. Good morning. Mr. Muela, applicant, stand up, please. Yes. Before I start, the court would like to pronounce the following. Be advised that permission to have this matter aired by radio or television or any other format has been granted. That's the technical aspect that we have to pass first. Further, this will be pronounced now. It's a ruling on a bail application which was submitted before this honorable court by way of affidavits by the applicant, and the state did not oppose it as well by way of affidavit. Now, the last time when the court was in session, which was the 6th of June 2019, the court will pronounce the following before it goes into the ruling itself. I'm going to pronounce without fear, favor, bias, or prejudice, subject only to the Constitution and the rule of law. That is what is going to influence my pronouncement. And secondly, the ruling will be very detailed. It's going to cover all the aspects that emanated or that transpired in this court before I pronounce on the ruling. It might take us some time to finalize it. Now the court is going to pronounce on the ruling for a formal bail application which was before court by applicant Mohammed Muela. Now, the court is going to warn the following before it gives the ruling. The court is also entitled to refuse bail if it is in the safety of the accused. The court has a right to refuse bail. The court refers to State v. Skedat, 1999, 1, South African Criminal Law Report 100, Cape 104. Evidence which was led before this court, no one told this court, the IO or the defense, how many times was the deceased stepped. This matter, this is the warning that I'm starting with before I pronounce on the bail. Despite the court having asked, this might have had an impact on determining the schedule of this matter. Because if it was many times, it could have maybe exceeded what we call the bounds of self-defense. The court will come to the affidavit by the defense and the state when it's going to finally pronounce on bail. The court finally again wants to advise that no timetable was handed in as proof that the accused is indeed writing exams. It is only by way of affidavit under oath, which in the hands of the court was never substantiated. And the court now is warning the public, fellow students and members of the nation at large. The deceased had a constitutional right of life. Equally, the accused has a constitutional right to education. And this court is an upper guardian regarding those rights. Now, the ruling is as follows. This, on the 6th of June, was a formal bail application which was launched by the applicant before the Honorable Court, namely Mr. Mohammed Muela. The applicant is a 19-year-old student person a South African citizen. He resides, I'm going to name the name of the physical address into the records. It's common cause, it's known. He resides at 153 Sheffield Street, Kenilworth, Johannesburg. He resides with his mother and his sister. The applicant is charged with 1 count of murder and 2 counts of attempted murder. The alleged offense is before the Honorable Court, took place on the 3rd of June 2019. That is part A of my summarizing. Part B, the investigating officer is Detective Mulalo Ramasia. He is the investigating officer in this matter. He is stationed at Boysen, South African Police Detective Services. He testified by way of affidavit. In short, he is not opposed to the applicant release on bail and has submitted an affidavit to that effect. Now the court goes now to glaring errors before the court, glaring mistakes. The affidavit by the IO or the state affidavit was not correctly commissioned according to the Act and did not comply with the Oath Act. The court had to stand down for it to be corrected into the records. The applicant's affidavit, paragraph 10, did not reflect the correct date of the incident. The court ordered the applicant accused under oath to have it corrected to reflect the correct date. The applicant had to take a stand. The correct date of incident was read now into the record as the 3rd of June 2019, not the 3rd of May as initially reflected. Paragraph 2.1 of the IO affidavit it has a glaring mistake as well. The court has to highlight it. He referred to the deceased as Daniel Malela and further referred to him as the accused in the same paragraph. The court is not impressed with that. Then the court asked itself whether did the state carefully study this affidavit. People who took the stand, the applicant himself, Mr. Muela, the IO, the investigating officer, Detective Ramasia, the spokesperson of the Department of Gauteng Education, Mr. Mabon. Unanswered questions before the court. The IO did not tell the court how many times was the deceased stabbed. The court asked the applicant how does he know that the deceased belonged to a gang. He simply answered that it is known that they are called Stouterkeners gang. Mr. Steve Mabona failed to assist the court regarding policy. When the court asked him about policy regarding a 19-year-old doing grade 11, as this, according to the court, translated in him finishing matric, meaning grade 12, at 20 years of age, if in any way he is successful. If this applicant never drops any year of study, he will finish matric at the age of 20. Mr. Mabona failed to assist the court about policy regarding that. The court asked this question as it is clear that the deceased himself, the court asked itself this question as it is clear that the deceased is in grades, he was 16. The deceased himself today was 16 years in grade 8, which translates in him finishing matric if he was alive and did not drop any year of study at 21 years of age. That is why it was paramount for Mr. Mabona to assist us, because it appears at Forest High, adults are studying. The School Act should be clear on that. It appears that school teachers are teaching people who are almost adults or who are adults. So Mr. Mabona failed to answer this question. This appears that the age of students at Forest High, we call it in Latin sui generis, or of its own kind. Whether the accused belong to a gang or not remains unanswered. Evidence was laid under oath that this man is not belonging to any gang, but evidence was laid under oath by the applicant that the deceased belonged to a gang. Such evidence was never placed before the court by the IO. The IO affidavit never stated that the deceased belonged to a gang. It's only the applicant's affidavit which placed the deceased to a gang. Because if the applicant himself was a member of a gang, it could have affected the schedule. Maybe we would be before court under Schedule 6, not Schedule 5. Facts before court. The detective on paragraph 2 of his affidavit stated that on Monday, the 3rd of June, 2019, at about 10 to 12, the deceased, Mr. Daniel Bakwela, a 16-year-old boy, went to Forest High where he is learning. He was in the company of his friend, San Kalenga Kenga, a 15-year-old boy, also a student at Forest High, doing grade 10, as well as Lufu Chiamba, a 16-year-old boy, also attending the same school at grade 8. It is alleged that both Lucy Jack Chiamba and Daniel Makwela, I said in brackets, accused, I highlighted it because the IO made a mistake on that one, were escorting such son Kalengani Kenga to write exams because on Friday, the previous week, the 31st of May 2019, Daniel Makwela, I said again in brackets deceased because he's carrying 2 caps, was assaulted by this applicant, Mohammed Mawela. Took out a knife and started stabbing both San Kalenga and Lufu Jack Chiamba. I highlighted it. IO in this paragraph contradicted himself on his affidavit under oath as he referred to Daniel Makwela as accused and further same as deceased. Now, Chiamba, who both sustained injuries on the upper body and lower body, and then stabbed Daniel Bakwela deceased on the upper front body. Mohammed was chased by Jack Lufu Chiamba with a shambok, assaulted only trying to scare him from carrying on the stabbing. Mohammed was chased by a shambok to scare him from further stabbing the deceased. Mohammed then ran away, disappeared, leaving the 3 injured behind, Jack Lufu Chiamba and San Kalengyani, were then taken to Southern Hospital, where they were treated and discharged the same day. The deceased, Daniel Bakwela, was certified dead on the scene by paramedics. Now, I'm highlighting now contradictions on the IO's affidavit as well as the applicant's affidavit. All these things I'm going to I've considered them when coming to my final ruling. The first contradiction, 1, the IO is silent about the exam. There's no way in his affidavit when he says, when he's considering bail, this man should be let out because he's writing exam. He only concerned about the community and the physical address. And on paragraph 3 of the applicant or accused, he mentioned that he wants to write this exam. So they are not talking about one thing. Number 2, contradiction, paragraph 2.1, the IO stated that the accused stabbed 3 people. Paragraph, and then the second contradiction regarding the applicant, the accused alleged that he stabbed 1 of the gang member. Now, the IO speaks of 3, he speaks of 1. Number 3, IO never mentioned that the deceased belonged to a gang. Number 3, the applicant accused alleged that the deceased belonged to a gang. Number 4, contradiction. The IO is silent about the attack of the deceased by a stone thrown by Muhammad, which resulted in the knife being dropped. Muhammad, on his application, is silent on having attacked the deceased on the 31st of May, 2019, Friday, in the company of his friends. And he only spoke about a stone thrown and the knife dropping. Number 5, the IO disclosed there was a previous fight. The applicant or accused under oath, number 5, contradiction, is silent about the previous fight. That is why the court said they are not helping me. The IO submitted under oath that Jack Lufuchiambo had to use a shambok to chase the accused, only to scare him from carrying on stepping. The applicant accused, on another contradiction, number 5, is silent that there was somebody scaring him with a shambok. Under oath. And the IO as well is under oath. And both of them were given the opportunity to supplement whatever that is under oath when they took the witness box. They elected not to assist us regarding these contradictions. The IO is silent about a security guard involved at the gate. Number 6, the accused or applicant said he ran into the yard and the security guard at the gate had to close the gate. And then he had to use the back gate to leave the scene. On the IO's affidavit now, it stated that he had the knife, the applicant. And then on the last contradiction, on the applicant's affidavit, he says the knife was dropped. Now, if somebody comes with a knife, it's premeditated. But if a knife is dropped, it's not premeditated. Now, this is what is purported to be as submitted by the defense. Now, is he an innocent victim? That is what the court is asking itself now, the questions. Is the accused purported to what his attorney is saying? Is he an innocent victim of an attack by the Stouterkenners gang? What is a premeditated murder? Sorry, was this, the court is asking this question now, was this a premeditated murder? If the court concentrates on the IO. By the accused who had a knife on his hand and stabbed the victim who he had already beaten the previous week. According to the IO affidavit, this accused has already beaten the deceased on the 31st of May. And on the 3rd of June, this accused is carrying a knife, according to the IO's affidavit. Or, the court asks itself another further question now. Or was this self-defense, as alleged by the defense on paragraph 10 of the accused affidavit, that on the day in question, I had come under physical attack by the members of the Stouterkenners gang, and the deceased dropped the knife he had after I hit him with a stone, then picked up the said knife as I was surrounded by members of the above-mentioned gang and stabbed one of these gang members as I tried to make way so that I can run for my life. These two versions before court. We are not a trial court, but this court, when coming to a finding, has to look at all these corners. The court now will place the sequence of events before court from the date of the offense. Accused committed the crime. on the 3rd of June 2019. His sister, who is unknown to the court, who never testified, but as submitted under oath by the IO, assisted with the location of the accused, or by evidence of the accused affidavit, assisted in the location of the accused to a place which the court is not going to name in record for the safety of the accused. The accused had been incarcerated for 3 days prior to the 6th of June 2019, which translates into today, having incarcerated for 7 days. The state is not opposed to the release of the accused on bail. Inquiry that this court had to do on the 6th of June, Meromuto on its own accord. The court goes now to the inquiry that this court had to carry when the court realized that the state affidavit and the applicant's affidavit have problems. There was the IO took the stand. The IO stated under oath that there was, I'm referring to that literally as the so-called meeting at the chief prosecutor's office. Both the state IO and Mr. Mzwamere, the defense, both the state and the IO were present. Nothing was substantiated into the records about this so-called meeting, as the meeting was not scribed. That is why the court refers to it as so-called meeting. The people in attendance at that meeting, according to the IO and the oath, was was Advocate Fushane, Mr. Mabona, the Chief Prosecutor, Advocate Fushane, Mr. Mabona, the lady who just graced the court now, Ms. Mujundukane, the IO, and I believe one Colonel Basi in that meeting. That meeting, I further refer to it as a casual meeting because there was no scriber. It's not assisting me in coming to a decision. This court had to ask the IO, how was the deceased family invited? Were the party involved in that meeting sensitive to the deceased family? The IO and the O stated that they were in court. We felt it was economic to have them in the meeting. The court is not impressed. It could have done in a professional and more sensitive way. They've just lost a child. Now the court comes to the law, meaning the court is halfway towards its ruling. Schedule 5 bail application, as this bail application is a Schedule 5 bail application, the court must satisfy itself that the applicant or accused is facing a Schedule 5 bail application or offense. This court is satisfied that what was brought before it is indeed a Schedule 5 bail application. This must be based on the allegations and the evidence that is presented before this court. For Schedule 5 offense, the accused must advance evidence to the court. Furthermore, evidence that it is adduced by the accused to the court must satisfy the court that it is in the interest of justice, that the interest of justice permits. The interest of justice must permit that the accused be released on bail. This is below Schedule 6. Schedule 6 bail application, the accused has to discharge that exceptional circumstances exist that justifies its release on bail. So the standard there is a bit lower. To the community at large out there, you must understand the standard for this bail application is not the highest standard. It is the one that is a Schedule 5 bail application. Now, the evidence may be led by way of affidavit or viva voce. In this hearing, the evidence was led firstly by way of affidavit until the court had to clarify other issues, and then substantiated evidence was led by viva voce. Steve Mabona, viva voce. I.O. Ramasia substantiated as it was not correctly commissioned. The accused had to take the stand viva voce for the court to correct the date, as he placed the incident a month earlier. When the court is hearing such bail application of a Schedule 5, it must conduct a careful inquiry before deciding the release of the accused on bail. This is what this court did by remanding this matter. The court was not under pressure. It had to remand this matter to satisfy itself if indeed it is in the interest of justice that this accused, the law permits that he be granted bail, and also to apply its mind carefully before granting this accused bail. The court also wants to put it on record that the purpose of bail is only the security of the accused or guarantee that the accused will attend or stand his trial until the trial is completed. In addition, the aim of bail is not to punish the accused. In terms of the law, every person who is detained for any crime have a right to apply for his release in court of law in a form of bail. Reference is noted to Section 50 sub B, which says a person who is in detention as contemplated in paragraph A shall, it means it's peremptory, as soon as reasonably possible be informed of his or her right to institute a bail proceeding, like in this case, this applicant or accused. Mr. Mwela, I'm warning you, you are in a court of law, you are not underneath the tree. Sit properly. Thank you. Section 60, sub 1A of the Act, 1977, Act provides that the accused who is in custody in respect of an offense shall be entitled to be released on bail at any stage if the court is satisfied that it is in the interest of justice to do so. Section 60 sub 4A until E grants certain circumstances where bail can be denied. There are circumstances where bail can be denied, where the accused release on bail will endanger the public safety, where the accused will avoid or flee his trial, where the accused release or accused will attempt to intimidate witness, where the accused release will undermine or endanger the proper functioning of the justice system, including bail system, where the accused will disturb or undermine public peace or security. In this case, there is no evidence from the investigating officer or prosecutor that this accused under these circumstances has that threat. That the state is not opposed to the accused released on bail and also drafted its affidavit. I'm putting the situation before this court. The state is not opposed to the accused released on bail. The IO as well has not opposed bail application. When the court is considering the accused bail application, the court must be able to consider the aspects. However, the final discretion, good people, is with this court. The final discretion is not with the public out there or whoever. It's with this court. This court is given the final discretion, and this court is going to pronounce. The accused used an affidavit for his bail and support, and the court correctly had to assist or help both the state and the defense applications affidavit. The state affidavit was not correctly commissioned. The defense affidavit placed the incident a month before it took place. As the court has indicated that the accused raised private defense on his on the allegations against him. His defense will be tested not in this court, This court is not a trial court. I'm not here to test his defense. The trial court will test the accused's defense. Despite public cry, nota bene, please, it's very important. It is not for this court to try as to whether he's guilty or not. It is for the trial court. Because this court is simply a bail court to determine whether the accused must be released on bail or not, based on whether the interest of justice permits for his release on bail. Section 60, sub 11 and B in Schedule 5 bail application, but not Schedule 6. The court shall order that the accused be detained in custody until he or she is dealt with in accordance with the rules, unless the accused, having seen or given reasonable opportunity to do so, adduce evidence which satisfies this court that it is the interest of justice permits that he be released on bail. Before I pronounce the order, we are coming to the finality of this bail application. The court is warning the schools, the court is warning the public at large that in the past, universities used to assist. There was what we call street law. Street law used to be available to children and young people regarding the general and legal rights, working with local youth groups. Primary and secondary schools. Our street law ambassadors have had developed materials and legal issues, such as police powers, access to legal advice, rights at school, the punishment regarding drinking and drugs. This used to be part of the curriculum in the past, wherein the departments like the Department of Education, as well as the community, were going to be more well-informed and clued up about the position today, rather than just making noise and an outcry out there without being informed. Now the court comes to the following. The court finds the orders are as follows. The order is as follows. The court finds that the interest of justice permits that the accused or applicant be released on bail. Bail is, however, granted not at 500 rand as asked or submitted. Bail is granted at 5,000. And I urge people must behave. I'm going to come to the endorsements. Bail is granted at 5,000. The accused attorney was asked on record as to whether he was a pro bono attorney. The accused attorney put it or submitted that he is paid by the family. The accused had the right to apply for legal aid if indeed he is a man of straw. He elected to appoint a private attorney that places him in a person or a family which is in a position to afford bail at 5,000. The attorney for the accused has never submitted a means test before court that justified the 500 rand, despite the accused being a student at school. The court granted the accused bail at the amount of 5,000. The accused is to be, the second order, the accused is to be relocated to the jurisdiction which is known to the court. The jurisdiction is known to the court as submitted by the state, the IO, and the defense. Detective Ramasia is aware of the place and will be doing the monitoring. So this is for the safety of the applicant before court. Now, the court is taking this exceptional stand of not mentioning his place because there was allegation that the deceased belonged to the Stouterkenners gang, and that allegation was never challenged before court. So it stands, and then it gives the accused the opportunity to be protected. The accused is ordered not to communicate with the state witnesses. The accused is not to enter the jurisdiction of Turffontein municipality area or suburb. The accused is ordered not to enter Forest High. The order that the accused is also prohibited from entering Forest High until his trial is finalized. The accused is ordered not to interfere with state witnesses, whether via school, media, physically, or through family or relatives. The accused is ordered to surrender his passport, if he has any, to the investigating officer, Detective Ramasia, and he is ordered further not to leave the country before this trial is finalized. If there is a challenge for him to leave the country, the IO must be contacted, as the accused will not be having a passport. It will be with the IO if he has any. The accused is to sign at a known police station, which police station is known to the state, the IO, and the court. And these are the endorsement for that police station, IO Ramasia, which is known to you. Monday, Mr. Ramabengani, please concentrate. You have to help him about the endorsement, not speak to counsel while the court is running, please. Now, Monday, between 6 in the morning to 18 hours, meaning 6 in the evening. The accused to sign again on Friday, between 6 a.m. to 18 hours, 6 to 6. Now, the Gauteng Department of Education is ordered that alternative measures be placed to the scholastic needs of the accused, as there was evidence that this man is busy writing mid-year exam. Specifically in regard to his mid-year exams, which evidence was placed before court that it might be disrupted or is already disrupted. The other order, where possible, the Gauteng Department of Education, where possible, is ordered to facilitate alternative measures practically possible within the School Act to encourage the accused furtherance of his studies. This includes possible relocation to an alternative school. The last order is in relation to the court, especially the clerk of this court, Mr. Yanga and company. The clerk of the court is ordered to keep this charge sheet or the exhibits of this charge sheet safe. They are not to be seen by members of the public. It could prejudice the safety of the accused. Ladies and gentlemen, that is the end of our formal bail application. Sir, you have been granted bail. You are successful. The interest of justice permits that you be granted bail. However, the endorsements were read into the records. Your attorney, Mr. Mabengane, will assist you in carrying and honoring those particular endorsements. Mr. IO, you will work with the state to see to it that his safety is guaranteed. Court agents. Mr. Mutamiri, do you have anything to add? Sorry, you may be standing down. We are now for the date of postponement. Sorry, Mr. Mutamiri. The matter is postponed to Mr. Mabengani and Mr. Mutamiri.
The 3rd day of July was.
Court? Which court? Court number 10. Good, suitable. Sorry. Now, the matter, Mr. Moela, is postponed to the 10th of July, let us see that is not a weekend. The 10th of July, 2019, for court number 10. And if you pay bail in the amount of 5,000, the court wants you to appear in court on the 10th of July, court number 10. You are on to appear at 8:30. Should you not appear at 8:30, the warrant of your arrest may be authorized and your bail may be provisionally forfeited. Now, the court remands you into custody. Thank you. I'm sorry, before we go, for the stenographer, as well as the interpreter, as well as the clerk of the court has not asked you to qualify yourself regarding us violating your Labor Relations Act of having lunch, sort of having break, because you are entitled to tea. Now, the court adjourns for the next 15 minutes to accommodate support to have their tea. Mr. Mzamiri, court adjourns. Thank you.
An emotional murder accused.